Okay, I'm gonna call this meeting to order at 1:04. Take roll. We have Geraldine, myself, Judge Hall, Laurel, Mark, Jeff, Thad, Deirdre, and Lauren. With Dr. Frederelli attempting to join. So we have quorum to begin. Before we start, does anyone have any to disclose anybody with them in the room? Okay, seeing none. Brandon, do we have any public testimony in this agenda item?
No hands raised.
Okay, thank you. Okay, so let's move on to agenda item B1, which is deliberation and decision making on the proposed bill. We got some proposed edits to the bill that was circulated from Mark and Jerry. I think there are 3 of them, so I think we should just take them in turn and discuss so that we can determine whether the task force would like to incorporate any one of those 3. So Mark, would you like to?
Sure. Yeah. Thanks. So, with regards to the first one, which is on page 26 that I'm looking at under section 502 civil action, the drafting pig made changes to subsection B. And I believe they made those changes because they were trying to edit to make it consistent with what it was reading, but just reword it. But in the process of doing that, it changed the meaning or intent of that section. So I'm just proposing that either the language be left as was in the original draft, or Jerry and I kind of drafted some language that we thought might make it a little more clear. But yeah, that's it with regards to that.
So the red line is what you and Jerry suggest, right?
Either that or that we revert back to what was in the original draft bill that Judge Hall had kind of put together that the pig reviewed.
I thought that there was in the draft bill that the pig reviewed, that there was an internal inconsistency where one provision said one thing and then the other one, they weren't internally consistent. And so we could draft them to remove that inconsistency, but I don't think we can just revert to that.
Sure. I think what was concluded, so the recommended change basically said only the birth mother could testify with regards to sexual access. But what the draft bill said and what the current HRS 584-14 says is that there is protection to the mother, but if there's an identified male and it's within the conception period, that somebody can provide testimony regarding that. So I'm just saying it should reflect that. So
Sorry, Deirdre, what was the inconsistency that was?
Don't remember because this version doesn't have the original that I had in front of me. It has, you know what I mean? It's their red line on top of the bill that they received. So I'm looking at the statute, and the section that Mark was just referring to says testimony related to sexual access to the mother by an unidentified man at any time or by an identified man at a time other than the probable time of conception of the child shall be inadmissible in evidence unless offered by the mother.
right. So when you break that down, it's a little confusing. But what it's saying is that if there's testimony regarding an unidentified male, somebody where, the alleged father is saying, hey, the birth mom had sex with some other guy, but I don't know his name, that's always going to be inadmissible.
Right, unless offered by the mother.
Right. If it's outside the conception period, inadmissible unless offered by the birth mother. But if, let's say, the alleged father is saying, I know that mother had sex with John W. Smith, date of birth, whatever, within the conception period, that's authorized. According to HRS 584-14. And that's why I cited to this case, because the statute itself was confusing to read. But when I read case law, it supports that in that situation, if there's an identified male in the conception period, someone other than the mother could offer that testimony.
So I would defer to Judge Hall on the question I'm about to ask. If there isn't a need to change the existing policy reflected in the current statute, I would replace it with the language of the current statute. Rather than what
That's
you
fine.
guys have done.
Yeah.
Because I think there's no need to change it. We're basically doing a reenactment. So I actually think, even though it is a bit confusing, it would be better to do that than to try to write something new. So Judge Hall, is there a need to change that provision, or do you think it would be better? That what we do is we would replace B with what is currently in HRS 584-14B.
Yeah, we can leave it as it currently is. That's not a problem.
Okay, well then that would be my preference, going with the simpler is better solution. I tried to find in my versions of the bill exactly what edits I had made that had the inconsistency, but doing it this way would just avoid that problem altogether.
I'm fine with that. I would agree with that. Absolutely.
Okay, well that's okay with me. I don't know if anybody, just as a drafting thing, that would be my inclination. If there's no need to change that policy, then let's just not change the bill. So.
And then Deirdre, just note, and I think you folks would do this already, but just to make it gender neutral language to be consistent with the rest, right?
Yes.
Thank you.
Yeah, I got no problem with that.
Thanks.
Thank you.
Sienna, does that make sense? Are we good there?
Yeah, I mean, so what we'll do when we get to the end of all of these, we'll have to do a motion and just kind of clarify which ones we're accepting, but what kind of been talked about here, section 502B, what we'll do is we'll revise the language to simply reflect what's in 584-14B with gender neutral language.
That's my understanding. Thank you.
Okay, so that was the first one on page 26. Mark, want to go to page 42?
Yeah, I think maybe Jerry will address that. I kind of am neutral on it, so I'll let Jerry talk to that.
Thank you. On page 42, section 604, adjudicating parentage of child with acknowledged parent. The recommended language, I'd like to change it slightly. B, parent 1, the individual shall commence the proceeding not later than 2 years after the effective date of the acknowledgement, unless good cause is, instead of established, substitutes the word shown. So unless good cause is shown. And the rationale is this: giving the non-signatory of this voluntary establishment of paternity document a 2-year time period in which to object and request to have the parentage establishment set aside is probably going to be insufficient time. The non-signatory will probably be the biological parent of the child. Because he is a non-signatory, he will not have access to the child's birth certificate and will not know that parentage has been established through the VEP process. It has been my experience in dealing with these parentage cases that often more than 2 years passes before the non-signatory is made aware that he may be the father of a child. I had a recent case in which the non-signatory alleged biological father contacted my office and stated that he had been away from Hawaii for several years. However, upon his return, he learned from the maternal grandmother who was raising the subject child that he was the father of the child. She allowed the non-signatory alleged father, who has no other children, to visit with the child, who is now 7 years old. The non-signatory alleged father has bonded with the child. The signatory father, the child, is incarcerated and has been incarcerated for a lengthy period. When he was contacted, he indicated that he was the birthing mother's boyfriend and not the biological father of the child. He has had no contact with the child, is not interested in interacting or bonding with the child. The alleged biological father, who has limited funds, is trying to seek legal assistance in disestablishing the parentage of the non-birthing parent and establishing his parentage of the subject child. Essentially, this is just one case, but it's, if you do have a 2-year deadline to challenge parentage by a non-signatory, or rather by a person who is not part of the adjudication process, it may not be in the best interest of a minor child to have such a 2-year deadline. And that would be my recommendation.
Hey, Jerry, I have a question. Is there, the good cause language, is there some kind of standard in some other, I don't know, from some other standing case law that we could, that you think would be a good standard to
Good
use for
cause
something here?
is very close to meaningless. It's whenever the court wants to do it, it's used in 1,000 different contexts. So if the task force is inclined to create this exception and Jerry is intending it for exceptional circumstances, it should say for rare and exceptional circumstances, not good cause, which means whenever they feel like it. Every standard order from every court says good cause in it.
Right.
Yeah. So
That would be fine with me for rare and exceptional circumstances.
because I think that's actually more true to what you're talking about. Like, it's a policy question whether that exception is necessary, but what you're describing is not actually good cause. It's way more than good cause.
It's a language that I've seen used throughout. To
Yes,
allow
but it
the court-
doesn't mean anything, Jerry. It means like a court felt like doing it.
Yes,
So I think
Yes,
if we're-
well, it gives it wide discretion. to
Right,
the
but
court.
here's the thing is that because I'm still trying to figure out how exactly this works, and maybe Judge Hall can tell me like what would actually happen in the circumstances under the current law for Jerry's hypothetical, because I can't figure that out. But if the task force is inclined to add this exception, I would go along with it, but only if it was drafted to be narrow. And the reason why is there is a policy benefit to having an end of the line about when it can be challenged. And for most circumstances, that is going to be positive and equitable rather than leaving it open indefinitely. So that's why I would only support a narrowly written challenge. So rare and exceptional circumstances or something along those lines. A court who really wants to do it in circumstances that seem to justify it will have substantial discretion, even with that more narrow language. They will have it for the circumstances you're describing if they needed it, is what I'm saying. It's
Well,
not the
court-
difference between the word good cause and the word exceptional and rare circumstances.
Yes, and for family court cases, as Judge Hall is well aware, the court has wide discretion in making its decisions, and that's the basis for any appeal, judging the court's decision in terms of the court having wide discretion. But if the group wants to, that's fine. I just need, I think, to allow the court to address these special situations. You have obviously the situation that was presented to me recently. You have an adjudicated father, a legal father who no longer wants to be. He's incarcerated. He has no contact with a child. He doesn't want to bond with a child. And you now have the alleged biological father who's returned. And grandma is saying, hey, I'm going to allow you visitation. And he's happy with that. He doesn't mind grandma having the child. He wants to visit with the child. And she's allowed that.
So Judge Hall, what do you think of this? Because I would very much like to know your opinion.
If we're gonna make it consistent with other family statutes that involve family court, good cause would be the proper term to use.
Okay,
We don't have anything that says exceptional or anything like that.
okay.
I
But are
agree.
you concerned about it being too big of a exception?
No,
No?
Thank you. You know, I also, I did not, include another section, but I think it's appropriate that we look at 605, which is on page 43, parent B, parent 1, and that is the situation you have an adjudication of parentage, but you have a challenge by a non-party, and that is probably going to be a biological father, alleged biological father, especially in those cases where you do not have genetic testing. And I would recommend that we include the language in parent 1, unless good cause is shown. So it read the individual shall commence the proceeding not later than 2 years after the effective date of the adjudication, unless good cause is shown.
Sienna,
It
the
would
term
be
in-
exceptional.
the term in other statutes, Sienna, for putting it in is just good cause shown,
Okay.
unless good cause shown.
And leave it to the court's wide discretion.
So that basically, Jerry, that's a parallel, right? You're making the
Yes.
same amendment to B1 in 605 that you're recommending in B1 in 604.
Yes.
Okay, I'm comfortable with it. If Judge Hall says that good cause is not going to be, overused, and that's the standard term for this kind of discretion you're envisioning, then I'm okay with that. And I also agree that if we put it in one, it should be in the other, both 604 and 605, to make them match.
Thank you.
Are those the only two instances? Does anybody recall? Because I think if we're going to do it in these two situations, I want to make sure that if there's another one, that we are consistent throughout. I haven't found
I think it makes sense for just those two because the acknowledgement is supposed to be the equivalent of an adjudication, right? So they're kind of, it would be like challenging, the equivalent of a judgment in both circumstances.
Well, so I think the issue is that 402.
Oh,
402.
402.
I don't know if I'd want to change 402 because if I'm reading
But
that
page are you
correctly,
guys
those,
on?
sorry, 18.
Thank you. Okay,
402.3.
I don't know if I'd want to change that one.
Well, I mean, you're inviting them not to meet the deadline. This is the notice to them. We should just tell
Right.
them the 2 years. I mean, let's not forget that somebody has to have signed this in order to wind up in this circumstance, right?
Oh, excuse me, are you referring to page 22?
Page 18 or bottom of 18 going into 19.
And that's governing the form for the acknowledgement of parentage, right? Like what notice you're gonna give them. And I wouldn't invite people to ignore the 2 years.
Here's the problem. It does say 2 years. However, if you look at page 22, it defines the period when the signatory can rescind the acknowledgement. It can be both mother or father,
Mm-hmm.
and father, or parent. And it would be F1. It's within 60 days of signature, and that follows the federal law. But also the federal law does provide in G, following the 60-day period referred to in subsection F, a signed voluntary acknowledgement of parentage may be challenged in court only on the basis of fraud, duress, or material mistake of fact, with the burden of proof on the challenger. So that is a period longer than the 60 days. It depends
That's
on
not the same thing, though. Rescission of it is being able to pull back your agreement to it. So it's like a take back, a do-over period. That's not the same as being able to challenge it under the circumstances within so many years and who has the burden. I don't think those overlap.
I don't think so either. 402 deals with the signatories.
Yeah.
604 deals with a non-signatory, someone that had no idea what was going on. That's why we want to provide some flexibility for them to maybe have a say after 2 years. But this deals with signatories who are part of it, so they're aware of it. So I think the 2 years is fine under 402.
I have to disagree. 2 years is fine there, but it conflicts with what is provided in the federal law. And that is, it may be challenged in court on the basis of, it's really a Rule 60B challenge.
Right,
which-
but we don't have to change that because the family court rules already have a Rule 60, right? So if they're gonna
Yes.
bring it under, oh, there's a cat. Hi, Laurel's cat. Okay, sorry,
Jerry,
I was distracted by the cat. Okay,
Jerry, the 60 days is something totally different, and the whole fraud duress clause is also something completely different than this provision. So there's two standalone provisions. You can
Okay.
still have the fraud duress after the 60 days, and you can have this 2 years.
And if you don't fall within the Rule 60, then you rely on that 2-year period. Is that it?
Not exactly.
If you're non-signatory,
Yeah.
if you're signatory, then you're bound by the 60 days plus the fraud duress.
Yes.
Yeah, I'm okay with adding the good cause to 604 and 605. And I don't think we need to change the earlier 60-day provision thing.
And I don't see any, I did a find using the term 2 years. I don't see any other areas that we would have to add that good cause language.
Okay.
Okay, so what was discussed here was that section 604B1 would be revised to add unless good cause is shown. And then 605B1 would also reflect unless good cause is shown. Okay. All right, and then the last one was on page 45. Jerry or Mark?
Yeah, I can speak to
Mark?
that. So the last one's on page 45. It deals with adjudicating competing claims of parentage. It changes the norm, which has been 2 parents, right? So it expands it out. It gives the court the opportunity to name 2 or more than 2 parents in certain situations that are laid out. And I think we just Jerry and I were talking, and we wanted to bring forth that there are barriers towards moving towards more than 2 parents. For example, the child support guideline worksheet as it's presently set up is not set up to calculate more than 2 parents or more than 1 paying parent. So there would have to be adjustments made to that. Same thing with the CSCA, our internal tracking system. We're set up to track 1 payor and 1 payee. Here in these situations, you could have 2 or more parents that may be responsible to pay child support. And then although I haven't spoken to Lauren at Department of Health, I believe their system is also set up for two parents and not more than two. So those would be some of the barriers. Really, this is something that we should have brought up earlier because I think it's a policy issue, not just a change in wording. So I don't know if we're stuck with it now. We did bring it up in our PIG initially, the legal parentage PIG, through an email, but I think we got focused on VEP, which was a big matter, and some other issues. It kind of got backburnered and just we never got back to it. So I don't know if this is something where it's too late to discuss and put to some type of vote. And if it is, then I think in the alternative, if somehow in the final report that goes to the legislature, we can at least note what some of those barriers would be if it was more than two parents.
May I say something about this? The concern is that the Child Support Enforcement Agency, its system is a massive statewide system, is set up for two-parent situation. It's not set up for 3 or 4 parent situation. Similarly, Department of Health, the birth certificate of live birth right now reflects 2 parents. But again, it's in their system to accept this information and track this information. So you will, you're talking about system changes of 2 separate state agencies, and the cost involved, the delay, it may result in the delay of the implementation of this proposed Uniform Parentage Act. So for those reasons, and again, the Guidelines Committee we had just met, the most recent is a 2024 Child Support Guidelines. We meet every 4 years. The Guidelines Committee may be meeting before, but another one is not anticipated and will probably not be issued until 2028.
Actually,
But more
Jerry,
importantly, yes,
we're 2 years behind. Technically, we're supposed to be done with the next one in 2026. We've been 1 to 2 years behind in doing it every year for the past several, probably decades.
yes, it's really been difficult to meet, and that has been the problem. I think although it should be 2026, I think it'll probably be longer, and that's been the history of the Guidelines Committee. It does take a lot of work, but more importantly, you're talking about system changes to the agencies, the Child Support Enforcement Agency and the Department of Health.
Laurel?
I'm just going to give a couple analogies. I think as far as Department of Health, I think I had mentioned that the current law does allow for more than 2 parents to be put on a birth certificate. So I don't know if it's going to be a Department of Health issue, but you know, regarding the payment and the payee system, when I was still working, the legislature told the employee retirement system, the pension system, that they had to start taking care of court-ordered payments. Their system was not set up for that. And the legislature said, well, too bad for you, do it anyway. Now, I realize, you know, ERS is a trust-funded operation, but we had to do it as trustees. So I would be very careful going to the legislature and saying, oh, too bad, we don't have money and we can't fix the system, because I don't think that's going to pass muster with them, even though, because again, child support is a non-general funded agency, if I recall. So.
And also just for some history, or not really history, but the last time this was put before the legislature, this provision was there. Department of Health did not submit any testimony whatsoever.
Judge, what does the current law say anything about more than two parents, or is it silent?
Not in our paternity statute, it doesn't say.
But someplace else it does.
I believe, not so much about having two parents, but like Laurel said, there is, and I'm sorry, I can't speak as to where, maybe Laurel knows. There is a provision somewhere that a birth certificate may have more than two people listed.
Okay.
It's in the
So-
adoption. I don't remember which section, but it's in
Um,
the adoption chapter.
So I kind of share Laurel's concerns about this edit. I understand that your guys' concerns on behalf of these agencies are totally legitimate. They're very pragmatic. You know, you want to, see whether it actually could be implemented on that level. But to me, that strikes me as a reason for the agency to, object or offer testimony to the bill. It doesn't answer the policy question about whether the court should be permitted to recognize a third parent in circumstances that justify it. Those are not, in fact, the same question, right? So I'm a little concerned about equating those two things. And I also am adamantly opposed to actually telling the court that it does not have discretion in order to serve the administrative, concerns of the agency. So if the bulk of the task force wants to omit this out of this administrative concern, I would just say nothing instead of saying the court may not adjudicate a child to have more than two parents. I don't see why that would be justified based on your administrative concerns, because in my opinion, that's going, further than it needs to go to address that. So, but I did have one logistical question, Sienna. What can we do now? Just kind of following up on Mark's question. Can we make whatever change the task force wants to make to the bill, or are we kind of restricted with just the, I don't really know the answer to that question.
So the reason we had to have the delays before, because they were reports from the draft or from the pigs. And so we
Yeah.
need a 2-meeting delay, but the task force can take its own action. So if we decide we want to, we can vote to discuss, or we can vote this provision in or out. And so if we want to specifically address this provision, and we can do a vote if that's what the task force wants to do, or if we can discuss all 3 of these changes, in or out of the bill. So the task force is able to make.
Okay,
decisions.
so that answers Mark's question about what are we able to do now, right?
Yeah, so we
so-
can vote in or out this.
Gotcha. Okay. So I don't know if that helps you, Mark, because I was wondering the same thing when you asked that. So anyway, that's kind of where I'm lying on this. I feel like I totally understand where the agency is coming from, but to have a state agency, recall I worked in government for many years, go to the legislature and say, oh, we can't do this because it's too hard / expensive / complicated. It doesn't work with our computers. That's actually not a policy response. It's a pragmatic response, but it's not an answer to the policy, right? So to me, what the task force should really do is answer the policy question as a group. And if the Department of Health or the other agencies pragmatically could not do this, then it would be up to them to point that out to the legislature if and when the bill is, moving and gets a hearing. So that would be my take on how to approach this. I definitely do not want to introduce a part of statute that forbids a court from adjudicating more than 2 parents. I think that's unwarranted. Anyway, that's kind of where I'm landing on it. And that's not to say I don't understand what the problem is. I do, but I think, we can't do it for some pragmatic reason is not an answer to whether it should be permissible by law, which is a different question.
I just wanted to add, I looked at the model law, and in the model law, this language does come from the model law, but it offers 2 alternatives in the version that I'm looking at, where alternative A says the court may not adjudicate a child to have more than 2 parents under this act, right? And it specifically delineates that. Alternative B is what's in our draft. And I guess my concern is that if there are other places in state law where we've already authorized more than 2 parents, then I think the policy call has sort of already been made for us in a way. And so I would be, I would lean towards accepting alternative B as it is, and also for the reasons that other folks have stated about going to the legislature and saying, well, we just can't do it, because I think that that would not go over well. So I too am leaning towards alternative, the current language.
What section is that in the uniform law, please,
It's
Mihoko?
section 613, at page 54.
Thank you. Okay.
And then
With regard
Sorry, page
to
55.
Okay,
Sorry.
thank you.
55.
It
With
depends
regard
on
to-
remember the different versions of that whole thing.
Yeah, I know.
Don't even do
I'm
that.
sorry. I need to go back and look which version. I'm looking at the final act with comments.
Okay, yeah, I'm looking at the that whole thing about the two different 2017s, but I'm looking at 2017, final 2019, and what Mihoko just described is on page 55 based on the bottom pagination. It's page 64 in
you.
the PDF.
So Judge Hall, you said that right now the paternity statute is silent about more than two parents, right?
Correct.
And there's not like the judiciary isn't clamoring to have that clarified in any way, right? Like they're not, no one's saying we need to make clear it can only be two parents, or we have to make clear that they're allowed to do more. Like there's not some kind of need that we put this provision in, right? From the judiciary standpoint.
From the judiciary standpoint, it would be beneficial to use so we don't have to pick between two. So in a situation we've had before, mom tells that guy A, hey, you're the dad. They get married. He raises the child as his own. Now they're getting divorced, and she wants to ensure she gets custody. So she says, oh, guess what? You're not the dad. Guy B is actually the dad. And so you have no parental rights whatsoever. And you have to get out of the picture, which is harmful to the child because that's the parent they've always known. But we also understand that Guy B has a right to be a dad too. So that's the kind of situation this would allow us to say, hey, both of you can be part of this child's life. Right now, we're required, the way we read things, we're required to pick. We either have to pick the de facto parent or we have to pick the biological parent.
Okay. So it would help you.
It would.
And
If-
you
and
know
if we
what,
left
Lauren,
it-
it is in the uniform law, right? Like,
Right.
Yes.
we're actually not making it up. So I didn't realize that. So I want to thank Mihoko for pointing that out. So I think what we would wind up deciding then, because that's essentially what the edit from Jerry and Mark has done, is between the two alternatives. Alternative
Mhm.
A court may not adjudicate a child to have more than two parents. Alternative B, which is the language that's stricken in this one, which would allow it. And that is the language from the uniform law, right?
Mhm.
Allowing in this circumstance a third parent. And I had not realized that the language of a birth certificate's statutory permits a third parent, more than two, right?
Mhm.
So if that's the case, then, oh, there it is, citation. Thank you, Laurel. 578-14A.
As well.
Amended birth certificate to include
Yeah.
birth parent names as well as adoptive parents, right? So
Oh, but
I would be inclined to go back to the way that the bill was when we circulated it and not accept Mark and Jerry's suggestion here, and to give the courts the discretion that they would benefit from having in the circumstances Judge Hall is describing.
may I see something about 578, 14A? You're talking about the birth parents and the adopted parents, the parents who adopt the child. In that situation, the child's birth certificate as to the original parents listed will be amended so that they are deleted from the certificate, and only the names of the adopting parents will be reflected on the child's birth certificate. You're not going to have multiple parents. You're going to have a substitution of parents.
Jerry,
Well,
be
that's
very-
not accurate. Yeah,
Please
that's
read
not-
that again, Jerry, because we specifically asked for that, particularly because of Hanai. So please read that carefully. This
Yeah,
is
I
the
don't think
amended
that's
birth
correct.
certificate.
Yeah, I'm looking at, I've got this provision that Laurel cited to in front of me. It looks to me like there's an option. So you could do it the way you're describing, but you don't have to. Did I get that right, Laurel?
But the birth parents would no longer be the legal parents, right?
If someone has adoptive parents,
Yeah.
like who has the parentage responsibility, that's certainly my understanding,
Right.
but in terms of whether state law envisions that more than two individuals could be characterized as a parent under Hawaii revised statutes. I agree with Laurel, 578-14A allows that.
Yeah, it says the adoptive parent can make that decision to.
Right,
include
upon the
birth
request
parent.
of both adoptive parents,
Right.
right? Or the sole adoptive parent if there is only
And
one,
one.
that the name or names of either or both of the natural parents appear on the certificate. So it's allowing for that possibility with the consent of the relevant parties.
You know, I'm reading it now and you're correct. I had
But
thought.
thank you,
though,
Jerry.
that in adopted, cases where a child is adopted, generally, the adopting parents do not want anyone else's names except their own.
Right, no, and I think we know that that is
certificate.
the way it was done, like historically. So I think
Yes.
that this, this recent addition is allowing for more flexibility because people have a much, sort of more open attitude toward adoption than they did, 50 years ago. So in any case, to me, the relevance of this to our current discussion is, does Hawaii state existing statutory law contemplate more than two individuals to be characterized as a parent? And the answer is yes, it does. So that option, and not that I don't understand your pragmatic concerns, I definitely do, but that option supports the idea of including the original text that we had in the draft bill, which is option B under the uniform law, to allow the courts the discretion to recognize more than two people as parents.
However, Deirdre, the other option is really to delete all reference to section C. And
That's
keep
true.
that.
We could omit it altogether and not say either option. We
Yes.
could give the courts the discretion that Judge Hall thinks would be beneficial and then leave the departments to make whatever objections they may have if the bill gets a hearing, right? Or we could go with the first option under the uniform law and say may not adjudicate a child. I'm not hearing a lot of interest in that last option. So I think anyway, yeah, you're correct. I guess there's three options for this section.
Yeah, I think I'm leaning towards including the original language about
Me too.
allowing more than two, and then, yeah, like you said, the legislature can always say, no, we don't want that, and the agencies can say why it might not be practical, but I think we should give them that option, especially because it's in the model law. And yeah, and they're very well within their right to just say no, but I think if we don't put it in at all, they might just not think about it.
Well, we should take a vote, and then my recommendation is that if you do leave the original language, that the comments and the concerns be included in our report to the legislature on this issue.
Yeah, I think we could do that.
Jerry, I'm assuming you mean the practical concerns about the lack of availability of the systems in place as opposed to the potential additional controversy it may cause?
Yes.
Yeah, I don't want to put anything about potential controversy into
Exactly.
the report.
Yeah, exactly. That'll happen on its own, but I agree the practical implications are worth noting.
Right, as long as it's brief, because we don't
Yeah.
want we don't want to treat
Oh,
as the report.
definitely.
Little teeny thing. I'm okay with that, as long as we don't mention the potential controversy. If somebody's got a controversy, they can bring it up themselves.
Yeah, so we can discuss what we might have to add to the report after we finish accepting or finalize the changes to the proposed bill.
Fiona, can we take a vote on this particular section as to the two options available? That is, leave the language that is reflected in the proposed bill, or delete it altogether.
So, I mean, I can entertain a motion. You can.
I'll make a motion that we delete all reference to the multiple parent situation that's reflected in subsection C.
So maybe let me clarify your motion. Are you moving to just eliminate subsection C from section 609?
Yes.
It's 607.
or
Oh,
60, sorry,
607,
607. So do I have a second to the motion to eliminate subsection C from section 607?
I'll second it.
All right, so I'll take a vote. I'll do a roll call vote just so it's clear. Lauren? John?
I'll vote no on that.
Okay, Jeff, Esmond?
Abstain.
Okay, Judge Hall,
No,
Carol,
I'm a no.
Dr. Federelli,
No.
Laurel,
No,
Mark,
Yes.
Geraldine,
Yes,
Mihoko,
No,
Deirdre,
No,
and I'm voting myself no as well. So that's 1, 2. So we only have 2 yeses and the rest are no, so that motion does not pass. Do we have any other motion? So currently-
I will make a motion that we include the text that would give the courts discretion as in the Uniform Parentage Act. So that would be the language that is stricken out by Mark and Jerry's suggestion, that we include that.
Okay,
I'll
so can
second.
Could I,
can I clarify that motion first?
Yes,
Um,
please.
Yeah, so is a motion on the table that we leave 608, 607 subsection C the way it is drafted in the original circulated bill.
The bill as circulated for this meeting, yes.
Okay, so I have Deirdre moving and then Judge Holly seconding.
yes, ma'am.
could I second with to modify, to add that we would add in the report the concerns about, the agency's concerns, I guess, the pragmatic ones.
I mean, I think we can do that separately.
Okay.
We discuss the report and we'll discuss.
Okay, sorry.
I'm okay with that, by the way. Like, that's what I thought we were doing, but
Yeah,
we were
yeah,
just
so,
voting on the bill right now.
yeah,
Okay.
we're just voting on the bill right now. So
Sorry,
the
focusing
motion-
on the bill, sorry, ignore my.
All right, so the motion before the task force is to leave section 607 C as drafted in the bill that was circulated for this meeting, right? I'll take a vote. Lauren,
Yes.
okay. Jeff,
Abstain.
Judge Hall,
Yes,
okay, Carol,
Yes,
Dr. Federelli,
Yes.
Laurel,
yes,
Mark,
No.
okay, Jerry,
no,
Mihoko,
yes,
Deirdre,
Yes,
and I am also voting yes, so that's 1, 2, 3. Right, so that's 8 yeses. So we don't, that motion does not pass either. But to be clear, nothing's been changed to the draft bill. Our draft bill was circulated with subsection C in it. There has not actually been a change to the draft bill at this time. To clarify for the task force. Do we have any other discussion about any of the 3 changes that were brought up or any other changes that need to be discussed before we vote on the bill itself as a whole?
I thought that we didn't vote on it, but I thought that there seemed to be general agreement about the other 2 suggestions made by Jerry and Mark, right?
Yeah, so the motion that I can entertain would incorporate the 2 previous changes that we discussed. Laurel?
so, sorry, this is a process question, so our options are going to be for voting yes, no, abstain, or can we do like a reservations type of thing, or do we know?
So for my understanding is that if you vote with reservations, I can't count it as a full yes, so I'll let you.
Yeah, that's fine. I mean, okay, we'll just do that and we'll see what happens.
Yeah.
Okay, thank you.
Okay, so do we have any other changes to discuss before we entertain a motion on the bill?
Can I just ask if, because I'm assuming we're not gonna get enough votes either which way, to pass, what happens if we don't pass it?
So we are currently short one person, that should be returning at 2. So we could table this agenda item and turn to our draft report and return to agenda item B1 when we have Thad back. So that we have a fuller task force. Does anybody object to us tabling this and moving to B2 for the time being? Okay, barring any, Brandon, do we have any public testimony on this?
No hands raised.
All right, thank you. All right, so I'm going to turn to item B2 for now. And that's deliberation on the task force final report. I know Laurel and Jeff both circulated some proposed edits to or and revisions to the report. Either you want to start the discussion?
Okay, I'm sorry. I thought you would just do it. You would do it and ask us to, but you want us to lead the discussion?
Well, I mean, in the sense that they're your revisions,
Oh,
right?
okay. Yeah, I didn't want to presume that we were leading the discussion. That's all.
Well,
Okay.
yeah.
Okay. Okay. Okay, the changes that I proposed, and I think most of them from Jeff as well, were of course in the birth heritage section. And honestly, most of mine, I was trying to conform the language between what had been written by the PIG in support and what had been written by the PIG in opposition. And it's mainly like using the word person versus individual and then trying to conform it so we're not, it gets confusing when first we're talking about a child and then we're talking about an adult. And all I was trying to do was make it a little clearer. I hope that that was accomplished, but really that was what most of that is all about. I just, and I know that Deidre had at some point raised, you know, an issue about using common language, right? And I know that's mostly in bills. But, you know, the word person is kind of defined in the statutes. Individual isn't really. And so I was just using that kind of logic when I went through this. So, but if you all found something that you think is confusing or mistaken, then please speak up. But it's basically starts on page 7, goes through on 8 and into 9. Where I just tried to use person instead of going back and forth between individual and adult and child. That's basically what I did. It was a little crazy making, but that was the intent. So I don't know if anybody has any comments on it.
I saw no problem with the changes in terminology on individual, child, adult,
Okay.
Yeah,
person.
no, yeah, me neither.
That
I think
seemed fine to
they're an
me.
improvement, yeah.
Yeah.
Also, I'm just trying to go through all of them here. It looks like most of it is that, yeah, Laurel?
Yeah, the
Yeah.
only substantive stuff is not until page 10.
Okay. Right.
Yeah,
For
the
me,
3 comments
yeah.
in the middle of page 10, yeah.
Okay.
Yeah. So that's my old bill drafter that comes out every once in a while. And I'm like, this isn't, we gotta conform to.
Okay, yep. So non-substantive and more for clarity.
Yeah, they're really not, I don't feel there, but I just wanted to give everybody a chance if they think I made a substantive change. And
I think all of those edits, you know, in terms of the use person and those other kind of line edits that Laurel did, they're good and an improvement. In terms of the more substantive comments on 10, I don't have any problem changing the reference to cost prohibitive to say something instead about cost increase. I'm not sure I agree that we don't actually know about the services that are being provided here, though, for the middle one. And then I don't have any objection to omitting the phrase or even negating, if that would help address your concern, Laurel. But it's not clear to me that we actually don't know what's
Can-
going on in the
Okay.
ground
Can
here.
can I ask a question though? Because one of the questions
Right.
I was thinking, just looking at these, I was thinking is, are these a list of the arguments that were made that led to the decision of the committee, in which case the characterizations are accurate, or are they a list of statements of fact? I'm not necessarily meaning, I quite frankly, cost prohibitive. I think the concern was not about minor increases in cost. It was about potentially cost prohibitive increases, but I can live with that change. Article 9, if there's a better way to phrase it, to make clear that there was no, comprehensive detailed study, I'm okay with that. Negating, the only reason negating is in there is because literally people find out the exact identity of their donor sometimes through DNA testing. So in those cases, yeah, anonymity is completely negated. If you know who your donor is, anonymity has been negated. So that was the reason that was in there. I'm not sure why it would be taken out.
Oh, I see. Okay, I get what you're saying. So maybe part of the way to address this would be to make it a tad bit clearer on the bottom of 8 to top of 9 that these bullets are meant to reflect the position of the task force's understanding rather than a statement of fact about these
I mean, if
things.
that's what it is, that's what I understood these to be doing was, look, these were the committee, if you look at the bottom of 8, it's like there was consensus on this issue. There was not consensus on the other issue, and these were the arguments that were made in favor of either side.
Yeah.
I still don't mind being clearer about them, but I didn't think we were representing any of this as statements of fact or detailed studies. But like I said, cost prohibitive. I don't think we were concerned about minor cost increases. I think we were concerned about cost prohibitive increases. But I guess, I'm not going to follow my sword over that change. Negating, I think it's a simple statement of fact. People figure out who their donor is through DNA testing. At that point, you have negated anonymity. You're still stuck with the same problem you're always stuck with, is your donor going to talk to you? But that's true.
Gotcha. Right. Okay. I
Right.
understand. I think the part that it may benefit from a bit more clarification, I'm looking at the small paragraph that runs from the bottom of 8 to the top of 9. Making it a tad bit clearer that these are the positions, reflecting the differing opinions within the task force, just like by a phrase or a sentence. I think
Or the
that would be
positions that were
beneficial.
presented, or
Yeah, something along those lines. I think that would be helpful because I think that would make it a bit clearer that we're not purporting to have like a comprehensive.
I mean,
you
I
know,
don't think even on the articles in favor, I mean, I don't think even the ones in favor were representing it as a detailed, comprehensive study on any of their things either.
Yeah,
right?
no, and I agree with that. That's why I'm thinking
Yeah.
any case, I think that maybe that would help address that concern a little bit, Carol.
Yeah. Well, I mean, Laurel's the one to ask more than me, really.
Yeah,
Laurel and Jeff.
Yeah, and the only other one that didn't get mentioned, so if we go back to page 9, we use a phrase about Hawaii parents, and I think maybe we mean intended parents, not Hawaii's parents.
Oh, yeah, and Jeff's. Wherever
Yeah.
Jeff said, wherever you guys
Okay.
said intended parents was totally
Oh,
fine.
okay.
Jeff, I was a little,
Okay.
the referencing considering using gametes. I think it's more than considering. I think it only applies to people who are actually using donor gametes. So I would even go further, but other than that, yeah, I think intended parents is fine. Obviously, it doesn't affect other parents.
but I thought so too, using intended parents.
Okay, well, okay, so let me just tell you why I made some of the suggestions, and yeah, the main thing about when I talk about we didn't really have a complete inventory, my brain goes back to the fact that when we pass new regulation in Hawaii of any kind of industry or profession, and or if it involves insurance coverage, there's supposed to be like an independent study of all this, and that's not been done at all. I mean, we relied on Dr. Fratarelli, who I have great respect for, is not impugning him at all, and Carol too. They were telling us this is the world of it, but the reality is we only know their world of it. And so I just didn't want the people reading this to think there was some comprehensive study done like's usually done, because it hasn't been done.
Yeah, no, that's
So
okay.
if there's some way to nuance it, and that's fine.
I'm fine with that too, to make it clearer that this is based on the information we had at hand or something like that, so that we can address your concern.
Even just a
Yeah.
small suggestion, I mean, in the third bullet point on page 10, instead of saying adoption of Article 9, 2024 would be premature and have legal effect. And you could just say it could be.
Might be or could be,
Right,
yeah.
yeah.
I was thinking the exact thing,
Yeah,
that it might, that it might be
That
premature.
might go in a direction, but I'm
And you could
okay.
even say have limited legal effect. I'm okay with that if you don't want to be so absolute, Laura. You know,
Like
Yeah,
say
that's-
could be premature
Could be
or may
premature,
have limited legal effect
may
or
have
something
limited
like
legal
that.
effect. That's okay. You know, the facts will come out as they do, because we, as you yourself noted, Deirdre, we don't even know what they mean by licensed. There's a lot of,
Yeah, I
you know,
kind of got hung up on that
inconsistency.
when I was looking
Right.
at the bill.
Yeah,
I'm okay with that. We could make that first sentence of the third bullet, just like Lauren pointed out, say something like could be premature and may have limited legal
Legal
effect
effect.
or something like that, which would then make it a little more deliberately vague or deliberately prevaricating so that we don't sound so sure when we don't actually, we have only the information we have at hand.
You could
Would,
even
would
say
that
given,
help, Laurel?
given uncertainty.
yeah, I think so, because, yeah, some of these legislators will wonder, I'm not saying it's a majority of them, but might say, well, you know, were these studies done to tell us what's happening? And, you know, because I know the AG did that one in 2018, but we didn't even talk about that. So, you know, I guess I should have brought that up at some point.
No, it's okay.
Well,
are we-
I think that would be a good way to make sure, because I think this is probably the most important part of making sure that it's not taken as like, we're stone cold certain about this, is this sentence. So if we were to water it down in the way I just described, I hope that would go a fair way to addressing Laurel's
Yeah.
concerns. And then the line edits about person and intended and that stuff all looks good to me and is an improvement.
And cost, like I said, cost prohibitive, you know, I wasn't worried about minor cost increases. I was worried about cost prohibitive increases, but if it gives people peace of mind to say cost increases, I can live with that. You know, I
We
think
could say substantial cost increases, something like that. I mean, I'm not worried about going up $5, right?
yeah, no,
so,
me neither.
yeah.
I'm not either.
Anyway, maybe that's a middle ground. If it's not just the choice between saying cost increases and implying that it's just a little bit and cost prohibitive, we could say substantial or possibly cost
possible,
prohibitive
yeah,
or something
possibly
like
cost
that.
prohibitive or something, yeah.
Yeah.
And then, like I said, negating, I think, is a pretty black and white. If you can identify your donor through DNA testing, you have negated anonymity, and that does happen. I'm not sure if I should say this on record or not, but we believe some of the people who have the same donor as my sons believe they have identified the donor. So that negates anonymity.
I guess it depends on how you view it, but I don't want to, I don't know. I think I would like Jeff's opinion because
I was gonna
I know
say
that he had a
know
concern
this-
about some of this.
a little bit into some of the comments Jeff has raised too. So Jeff, if you'd like to.
Sure.
Let's start on page 9, right, Jeff?
Yes. So I put in the phrasing, Hawaii's intended parents who consider donor gametes, and in a way that's a slightly larger group than those who actually use donor gametes, because it's part of the process before you actually choose. So I'm not sure if I thought that consider was broader than who use donor gametes.
Yeah.
So I'm going, my preference is still with consider. That's the first. The second one is pretty much the same, slightly different terminology to match the sentence, the same as the number third. I like what you guys came up with possible cost prohibitive increases. I don't necessarily agree with or even negating. I don't know that an argument on bill that there's other stuff out there is necessarily a legitimate argument, saying it's okay if we do this because of that. I prefer not to see or even negating in there. I understand that there is a difference of opinion on that one. My comment on the bottom of page 10 is basically that the statement that the majority of the task force believes that the adoption of Article 9, 2019 will substantially improve Hawaii law. And my position on that is we voted on something, but a vote doesn't necessarily imply a belief on something that we did not necessarily vote on separately.
We could rewrite that sentence, Jeff, to just make it sort of more factual that the majority voted to adopt this portion as the task force's recommendation. But we are making policy recommendations in doing so, right? So if you want to take out sort of believes, and there would be a way to massage that sentence a little bit. However, I think you do need to be clear that the majority of the task force
Well, if you said
recommended
agreed.
and voted on the adoption of the 2019 version. Because
you
that's what
just-
happened.
Even if you
Yeah.
said concluded, agreed, voted,
Yeah,
decided.
something along those lines. We could I kind of see what you're getting at, because it kind of implies like a level of, sort of philosophical
Faith in the
engagement that
system.
it wasn't really what was happening. So if we just kind of make it a little blander, that might go, I hope, some distance toward
concluded.
identifying your concern. But I do think it is important that we are clear that the majority of the task force voted to include this particular provision in the proposed bill, because that's why it's there.
I do think it's clear because that's what it says in the sentence before. I could see an improvement to the set. I didn't want to take it on myself at the time to re-edit this particular sentence, but if we replace the word believes with voted, and I think we need to delete will substantially improve Hawaii law, because that's a very subjective comment that doesn't necessarily go for vote, and then leave everything in.
Yeah, I was thinking you could maybe do something like the majority of the task force recommends adoption of Article 9, 2019 with the goal of doing 1, 2.
1, 2. Yeah, I
Yeah,
like that.
something
That
like
makes it
that.
more bland and factual. Yeah. That seems good to me. That seems like a good compromise, because you still got the meat and potatoes there, and you've taken out kind of the philosophical, cloudy stuff that was also in there.
I think that's great, Lauren. And then my last comment, just I think it's a privilege that we have Dr. Frederelli with all his accomplishments, and so I just felt that the footnote should refer to him more appropriately.
Do you want all your awards and your big titles in the footnote? He doesn't want to, Jeff. I think you're embarrassing him.
Well, but
And if it
he's
happens
being-
to, if it happens to emphasize any potential perceived conflict of interest, we'll include it too.
I mean, it's important that we have someone representing all of that.
But
helping with-
that's why he's on the task force in the first place, right? So
Right.
I would
Correct.
say if Dr. Frederelli is uncomfortable with all these extra letters after his name, that we leave it out.
I leave it up to you, Dr. Frederelli.
Yeah.
I saw it there and I don't mind. I'm okay. I thought I was just being
Awkward.
if there's a problem, it was going to come back to me that I was the one, so that's okay.
Dr. Frederelli, will your wife be upset that you get all this recognition?
No, I don't think she really cares.
Oh, okay, okay. Then it should be okay.
I kind of like it there because it gives substance to the broadness of our committee.
Yeah, and also that particular point, in terms of relying on his on-the-ground expertise. So I'm okay with it as long as Dr. Frederelli's okay with it. And thank you for suggesting that, Jeff.
I will note that Dr. Frederelli's affiliation is described at the top where we describe all the task force members, so it wasn't completely omitted, but we are all okay with having it there, and Dr. Frederelli does not object, it's fine.
No, I gotta go look at my resume at the top though now, because I'm worried.
Yeah, no, I don't have anything fancy in mind.
Do you have all my degrees? Because I'm worried.
I want the special session citation for the Marriage Equality Act attached to me.
Remember, we wanted the pages to be less than 12.
Oh, right,
So the
okay.
report
Well,
has to be-
a session law site is not that long.
So
Okay.
Sienna,
Yeah.
I'm not sure if we're done with that portion of editing, but separate from that, I actually had some questions to ask the pig.
Can we, did we figure out that thing about the negating phrase? Has that been resolved? The rest of it, I feel like we arrived at a comfortable discussion, but I feel like it's okay to take it out because I see both sides of this. I mean, technically speaking, if you can, using DNA tests and information online, identify your donor, then the anonymity has been negated. But just because you can do something roundabout doesn't mean that the law has mandated it. right? So that's why I think it goes a long way toward mitigating the impact of donor anonymity. To me, I would not object to just omitting the phrase, if that would, get us to our more comfortable position on the report.
Once again, it's not something I follow my sword over, but it's not referring to the law. It's referring to the donor screening process that helps to mitigate donor screening process, availability of information in other sources, and things like that. Availability of commercial genetic testing is what's mitigating, not the law that we're passing. It's pointing out there are other things out there.
I just,
Yeah.
I don't feel strongly about it.
Yeah, it's okay. I mean,
yeah.
negating is part of mitigating. So like I said, I'm not going to follow my sword for this one either. I think it's more accurate technically because there is no anonymity left once you identify the donor. But if we want to soften that for reasons that it makes people feel better, we can do that.
Okay with that too.
Yeah, I'm okay taking it out. I think that we're probably going to get a lot of testimony, or the legislature is probably going to get a lot of testimony. I think the whole mitigating or negating effects,
Yeah.
are going to get kind of fleshed out there.
True.
So I had a couple more questions, which may or may not relate to editing. Is this an appropriate time about this section?
Yeah, so I think we've addressed the red lines that were provided by both Laurel and Jeff, so, satisfactorily. Okay, so yeah, we should move on.
So I wanted to ask about this last bullet point that starts with practical limitations. I read it and, with positive outcomes implied as, a good thing here in terms of voluntary donor cooperation, I actually read this as an argument in favor of 2024 over 2019, because I think it's fair to assume that a donor group that is all identifiable is going to give more cooperation than a donor group that's not identifiable. So I was just curious, how does this support 2019 over 2024?
I think that takes me back to my original question, which is, are we not at this point summarizing the arguments that were presented to the committee and making it, or the task force and making its decision?
Yeah, that's what I thought. So we're not I thought it was included because that was one of the reasons why the majority of the task force made the vote that it did, right? And it's not to say that I don't understand your point, because it's fair to say it, but the fact of the matter is you can know everything about your parents and have them be completely disengaged from your life. They choose to be actively engaged as parents because they choose to do so, no matter how they get there, right? Get to be a parent. So in any case, I don't see any need to change this because this is accurately reflecting one of the conversation points and points of interest for this vote.
Okay, I mean, I agree with the paragraph. It's just that I see it under a section that supports 2019 when I read it as supporting 2024. That's the reason I put the question out there. I can move on.
Okay, thank you.
I really just, I'm still also confused about the intent or meaning of the 2 bullet points above. And I like the wording that we came up with about adoption of Article 9 could be premature and have no legal effect. But the part I'm confused about is just at the beginning, we talk about unwarranted governmental intrusion, and then we said it might not have any effect. And so that just throws me off.
Jeff, those were the reasons why the people in the majority voted as they did. It's not intended to make sense to someone who doesn't share that point of view. So I understand you think that those things are contradictory, but it doesn't mean that they are. I mean, to me, I definitely understand both at the same time. So if it's accurately reflecting the conversation of the task force and arriving at the vote that we did on this issue, then the report is doing its job.
Okay, thanks. I mean, I've read it many times and I see it contradicting each other, but I see what you're saying.
I mean, it can have a substantial effect on the community, but also we are concerned with the government intrusion. So they are separate, reasons.
Right, because the government could enact a law that would have no pragmatic, influence for some practical reason. But at the same time, the law could be ridiculously intrusive and people would be offended and they would be unconstitutional. And those two things can happen at the same time.
But either way, I think these were both considerations that the task force is to guide their vote, so I don't see their like to remove either or to change either.
Yeah,
Okay.
it's like multiple reasons for voting as you did. It's not exclusive of one or the other.
Okay, thanks.
Yeah, I think I just wanted to add that I understand what Jeff's saying, and because we're looking at it, well, I will include he and I, from like a more global policy perspective, and I understand there's conflicts of law all the time. But to a reader who's not an attorney, see, when I try to step outside of it, which I realize is difficult, we're saying, well, we're okay with this amount of government intrusion, but not that amount, I guess, is what you're saying. And it to a reader, I think it's confusing, but because, you know, someone could say, well, why do you have any Article 9 at all?
I think you could,
So,
and
I think that's all he's trying to say, I think.
Yeah, no, and it's a fair question. I mean, honestly, any policy question about anything really interesting at all, you're going to run into exactly those questions, you know, but the closer you get to the most intimate decisions that people make, you know, the stickier it gets. So I think, although I do understand, you know, Jeff's point that like, if it has no legal effect, how intrusive can it be? Like there's a logical thing there, but you can have multiple reasons to, as you know, the group that I was in, the majority on this, multiple reasons to, you know, to prefer this policy choice. And so I, for myself, will say that including both accurately reflects the reasons why I voted as I did and as I articulated to this group. So I think the report does a good job of summarizing it. And I'm glad that we put some good length into this section because, you know, we spent a lot of time on it.
Do you think there's a way that like just reading this, you know, I like to Laurel's point about like an average reader reading this in that section on page 9, calling the arguments in favor of Article 9, like summarizing what that actually represents rather than calling it Article 9 2024 and Article 9 2019, just because I think you get really lost in the details of what we're even talking about. Or making it clear somewhere above that like giving each one a title somehow to organize the reader's thoughts.
I think some of that complexity can't be avoided because
I
you
know.
know the Uniform Law
Hard.
Committee has been changing, you know, doing different editions and then not even getting into the fact that 2017 exists twice. But I saw, you know, that Sienna had basically done as good of a job as you could addressing that potential confusion at the top of page 8. So, you know, I'm all for like,
I just think this is going to go over people's heads completely. Actually.
Yeah, but I expect that a lot of the rest of the bill will too. I mean, I had to spend some quality time with the assisted reproduction things before I realized the interaction between assisted reproduction and surrogacy. So, I mean, I think the bill is complicated. It's a lot. So I feel like we've articulating something that we spent a lot of time on. We're giving it a lot of real estate in the report. We're laying out the competing things. And, you know, I think we should leave it as the way it is with the adjustments discussed today. Yeah.
I'm just suggesting.
I see if you could just in like 3 or 4 words describe what the effect of 2024 and 2020 or 2019. I think the issue was when we did that, there was problems with the like, how do we describe what is 2024 doing? Because it's not mandatory disclosure, right? Like, you know, that is not accurate. So what would we describe the effect of 2024? And I think that kind of trying to like put that, and this is why also to clarify, there's no chart in this report, although we really attempted to make a chart for showing kind of how the parentage laws because
the chart was so nice.
Too bogged down, like, okay, there is actually a lot of detail here that we're eliminating, which makes it not precise or not accurate enough. And
yeah,
so the only concern with kind of trying to like sum up 2024 or 2019 in like a couple of words, because it sometimes then gets inaccurate in ways
Yeah,
that.
I gotcha.
I feel like
Okay.
the other thing too is that this report, you know, like with the adjustments, you know, the refinements that we talked about today is going to be a reference for people going forward, right? Like it's actually better for it to have something that you can really think about. So I really think that we've balanced it right. It's not super long. You know, obviously it's not really an easy read for somebody coming new to this topic, but I'm not the bill is 100 pages, you know, welcome to our world. So I think we should leave it, you know.
I'm good with that. I just wanted to
Yeah.
raise it because
Yeah,
I do
no,
think that
it's fair, but you know,
you're gonna face problems at the legislature
oh, for
of
sure.
anybody understanding what the hell this even says. I
Right,
mean, that's
not the
just
first time, right? So what's going to wind up happening, as you
the
very well
reality.
know, so what's going to wind up happening is the bill will only move if it gets some good, you know, advocates and allies within the legislature who pick it up after the task force reports on it. And those are the people who will actually spend the time really studying it. And it's for the benefit of those people that I think the detail in the report matters, not for the person who goes, you know. So will be a lot of people, right? Like that's the way it is.
Sarah, with regard to what was discussed today about the changes being recommended to the bill itself, as far as page 45 and the concerns about the two parents section, can you incorporate the comments into the report?
Yeah, so we can discuss that now. So I think it seemed like the general consensus was that we would just add a short description of some of the practical considerations that allowing for more than two parents would.
Yes, and I think maybe for sure the first paragraph of Mark's comments and the second is probably what should be included. The third paragraph, well, no, it can be deleted. It appears on page 45 of the proposed bill.
Yeah, so you're saying that the first two paragraphs in the comment are what you would want to put into the report.
I don't
Yeah.
want to mention potential opposition.
Yeah, so I guess, you know, the task
So,
force
yeah.
kind of wants to, we would incorporate the first section that ends with more than two parents and of discussing the practical concerns.
I would agree with that. I'm fine with that.
I agree with that too. And I think you can just essentially use what Mark wrote there. It was Mark, did you write that? Sorry.
Yeah,
Jerry, did you
yeah.
write? Sorry. Anyway, the first paragraph. The last paragraph is about our internal processing. And if somebody's going to oppose it, they can do it themselves. We certainly don't need to flag that.
Yeah.
Yeah.
The first paragraph to be
Yeah.
incorporated in
Yeah.
the section on legal parentage. Jeff, did you have something to say?
When we're done with Jerry's inquiry, I still had one or two more comments. I was hoping.
Yeah, I have that on, yeah, I have you. Okay, so yeah. Thanks, Jerry, for that. We'll
Thank
definitely.
you.
Okay, other comments, questions?
So first of all, thank you to the task force for giving me some time and listening to me. I appreciate it. There's just one thing that I just can't seem to stay silent on. It's at the top of page 10. I just would like to express my personal opinion about it. And I'm talking about the use of the terminology one night stands, which I have to return to. I understand the argument being made in this paragraph, and I don't really need that explained to me. And I understand that the term one night stand might be well intentioned and sincere in the goal of supporting that argument, but having gone through the donor selection process myself, which is long, it's a long drawn out, thoughtful, involved process. just find it so personally offensive that this comparison is included, because no matter how I read it, and I've tried to see the perspective of the pig that approved it, I see it as a comparison between the two. And in that list, one night stand is the only factor presented that is actually an alternative means of getting pregnant. But choosing a donor, at least for myself and my husband, is not a random thoughtless action of immediate gratification. So I understand that just because I find it offensive does not mean others will. And even though other task members may see nothing offensive about it, does not mean that everyone will agree with them either. But I just would like to see it removed.
Jeff, would anonymous intimate encounter make you feel better?
Or like casual sex? I mean, maybe I'm being more blunt than Carol.
It's not equating the two things, obviously.
No, it's not meant to equate them, but I mean, I think we need to refer in some way to the fact that heterosexual couples can make a baby by accident and just with some one encounter. So, but I don't care how it's referred to. Like if you want to say anonymous sexual encounters, casual sex, instead of one night stands, I understand your concern. Would that address it? But I do not want to take it out because that is a biological fact.
But if we said single encounters, it sounds a little.
But it has to be anonymous, so the point is lost. I mean, the point is you can have a single encounter and still know who the father is. But when a lot of my adoption cases, unfortunately, come from people who have anonymous encounters with somebody they don't know, and they don't know anybody who knows them. They have no way of contacting them. Of course, as you know, Judge Hall, I'm not lecturing you because you signed the you signed the orders for notice by publication.
And I just wanted to point out, I don't think we're saying that they're equal, because I think what we're saying is like, this is so unfair, you know, for people who do have to go through like a incredibly long, expensive, you know, taxing process. You know, we don't want to impose additional, you know, burdens on them when other people can just, you know, it's just so easy for others. I feel like, to me, it makes it like I'm not comparing them in my head.
Yeah, it's contrasting.
Yeah, I don't, they're not meant to be comparing, and I'm okay with replacing one night stand with some, you know, more mundane way of explaining the same phenomenon, right? But to me, for me personally, now I'm not speaking for anybody else, part of the reason why I voted as I did on this issue is because of the level of intrusiveness in these intimate decisions. And because in no world can I imagine that the Hawaii legislature would tell a straight woman that she can't go get pregnant with some random guy. There's no way. Now, I don't think that's an intelligent decision, and she shouldn't be doing that. It's very foolish. And I actually would much rather somebody went through the trouble of becoming a single mother by going through a donor. I would. However,
I appreciate that.
Thank you, Carol. But the real point is that the government shouldn't intrude in that decision. So to me, that matters, that the fact that I can't imagine the government saying you can't have an anonymous sexual encounter and then keep that baby. The government would never do that. And if they wouldn't do that, then the parallel is they also shouldn't eliminate the possibility of anonymous donors for LGBT couples. That's part of my logic. I don't know whether that motivates anybody else. So for me, it's important that it reference, you know, the one night stand factor, but I'm perfectly fine with using something less offensive as the phrase.
Deirdre, I like your terminology, anonymous encounters.
Anonymous, that was Carol actually, but yes, anything like that would be fine. Right, okay.
Yeah.
I totally understand that it is kind of flippant and was not meant to compare at all to the seriousness that any couple would approach, you know, a donor. I certainly did not mean that.
I do still think it should be anonymous intimate encounter or anonymous sexual encounter, obviously, to make it clear what we're talking about.
Okay, yeah, either one of those is fine with me too.
Anonymous sexual encounter.
Yeah.
Okay.
I mean, it might as well be clear what we're talking about.
Dr. Ferrari, did you have something to say?
No, I was going to echo what Carol just said.
Okay. Anonymous sexual encounters.
Encounters.
Yeah, we were workshopping certain terms. We left it as it is because it's very recognizable, but we can change it. Yeah.
Actually, that would cover assault as well, so that might actually be better.
Yeah.
Yeah.
Yeah, I mean, certainly, it doesn't imply consent to the same extent.
So that actually might be better. Yeah.
And technically, anonymous encounters in theory could be more than one night, I guess. So.
Mm-hmm.
I don't even want to know what these people are thinking, but moving on.
Thank you. Thank you
I
very
just
much.
wanted on record that all of that behavior is ridiculous and unintelligent. However, the government should not be telling you what to do.
Exactly.
Okay.
Thank you, guys. Thank you. I think it's great. I just wanted to say one final thing, just to explain my voting to abstain. I don't represent myself. I represent the Commission on Fatherhood, and due to the timing of the reports, did not have an opportunity to bring them in front of the commission. So for ethical and maybe even legal reasons, I cannot vote one way or another, which is why I'm voting abstain on these. Thank you very much, Sienna.
Yep, thanks, Jeff. Does
Thank you,
anybody
Jeff.
have other comments, changes? So I have a couple, I'm not going to rattle them off unless someone's very concerned about them.
Oh,
They're like,
Sienna, just one thing. I have an absolute hard stop at 5 minutes to 3.
okay,
Okay.
yeah, I think we should be okay.
Okay.
We have, just to let the task force know, I've got like some small like nit revisions, which are kind of for clarity, typos, missing words, and that I would ask when we have our motion that like I would given the authority to kind of incorporate the changes we've discussed here and to do proofreading and make changes so that it's clear and proofread appropriately. So does anybody have any other comments or things that they'd like to discuss as far as like the word choice or anything else on the report before we entertain a motion on it?
Can I ask, okay, so we vote on this, it's gonna go to Ledge Division, right? Once you do the edits that we vote on, does it come back after that?
I don't know. I would anticipate that unless the task force, unless something like substantive needs to be changed, the task force can kind of vote to say this with, non-substantive like editing revisions to be made, and like the task force can vote that this is the final report with the changes that were discussed.
The changes, yeah, that we vote on, and probably also we have to say we're okay with whatever the Ledge Division decides to do.
Right, as long as it's not making,
As long as it's not
it's
substantive
insisting on a
change.
substantive. Do I like that? Because that would mean that we're done and we're just handing it to Ledge Division to make drafting and non-substantive edits. And then it would go, with those final edits, it would go to the legislature at the end of the year.
And then we don't have to vote on it.
You wouldn't have to come back and meet again unless there's some reason.
Yeah, Laurel, comment?
Just a
Question?
process, again, will we be given the thing before or at the same time as transmitted to the legislature? I mean, I know how it gets to the legislature, but they don't post it till opening day because they can't do it until the legislature convenes.
All right, so if we can send you a finalized
Okay.
copy.
You can have the PDF,
I will send
all
it to you as long as
160 pages of it.
just like as far as like as long as we vote kind of as we're discussing, I won't send it to you for comment. It would be sent
Oh,
to
no. I want it once the legislature, the AG is ready to send it to the legislature. I don't need it before then.
Okay, yeah, Lauren?
Yeah, I want a copy then too.
Yeah, I will circulate a copy to the whole task force.
Okay, good. Okay.
Lauren?
Sorry, I think I accidentally did that.
Oh.
So Sienna, are you telling me I need to make a motion that Sienna be able to fix the typos? Because so moved if necessary.
I was going to, I'll propose a motion. I'll propose a motion for someone to move that the task force accept the final report with the changes that were discussed during this meeting and any other non-substantive editing changes, and that it give me the authority to transmit that report to the legislative division and work with it to finalize and send to the legislature when finished. Provided that any, hold on, provided that any substantive changes be brought back to the task force.
Okay, now I'm so moved.
Okay, Deirdre's moved it.
Second.
Okay, Laurel Carroll seconding. All right, I'll do a roll call vote. Lauren?
Yes.
That's that.
Yes.
Jeff?
Abstain.
Judge Hall?
Yes.
Carol? Carol,
Yes, sorry.
That was funny.
Dr. Ferrarelli,
Yes.
Laurel,
Yes.
Mark,
Yes.
Geraldine,
Yes.
Mihoko,
Yes.
okay, Deirdre,
Yes.
and myself voting yes. All right, so that motion passes with 11 votes. So we have what are going to be our final report, yay. And so that action item is complete, and we're going to return to the tabled action item, tabled agenda item B1. So we had discussed a couple of changes, like I think the task force had indicated that they were okay with making. So I'll put on a motion for someone to move that, a motion to accept the proposed bill as circulated with changes to section 502 as discussed by the task force, and changes to section 604 and 605 as discussed by the task force, and authorize me to present it to the legislative division and the authority to make any non-substantive clarification changes, and then to transmit to the legislature, provided that any substantive changes be brought back to the task force. Can I get a motion?
So moved.
Right, Judge Hall moving. Can I get a second?
Second.
Second.
Oh, no, let Thad do it.
Second, okay, I'll do a roll call vote. So Lauren,
Yes.
Jeff, oh, sorry, Thad,
Me, yes.
Jeff,
If that's Jeff, I abstain.
yeah, sorry, Jeff, yeah, abstain. Judge Hall,
Yes.
Carol,
Yes.
Dr. Ferrarelli,
Yes.
Laurel,
I'd like to do yes with reservations regarding
Okay.
Article 9.
okay. Mark,
Yes.
Geraldine,
Jerry.
Mary,
We can't hear you.
Yes.
Mihoko,
Yes.
Deirdre,
Yes.
and myself voting yes. So 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 yeses, 1 yes with reservations and 1 abstention. So that also passes. So I will take this,
Yay.
the draft bill as changed, as discussed here, and take it to the legislative division. Brandon, do we have any public testimony?
No public hands raised.
Okay, all right. So with that, those are our 2 action items. We are complete, and we can.
Wait, Judge Hall
Judge
has her
Hall
hand
has
up.
a hand.
Oh, sorry, Judge.
I just wanted to say thank you to everybody on this task force. I know I'm the one that caused all these problems. I take full responsibility, but I do think this can lead to much better things for our law and bringing it up to date. And I just wanted to show my appreciation to all of you for all the time you spent on this, all your hard work. It was unbelievable how much each of you have provided to this, and thank you so much.
Yeah, I wanted to say something similar. Thank you all so much. And a huge thank you to Sienna for taking care of this one.
Yay.
Wait, I'm still not back at work yet.
Yeah, we're all in
she's-
favor of
she's
babies on
doing-
this task force. Yeah, where's the baby?
I know, we still haven't seen a baby.
I know.
Not
I'll
even a
send-
picture.
I'll send you guys. I'll send a new picture. He's sleeping again. I don't know if he woke up and cried. I don't know. I had to mute while he was doing that, but he's back to sleep.
Go pick him up.
My husband's doing a good job. Just he's nap trapped right now. But yeah, thank you guys so much for volunteering so much time and giving all of your expertise. When I was assigned this originally, I had no idea what any of these laws were or the background of any of them, and it's just been amazing to learn all about it and to see how many people really care about it. So thank you guys so much. And there've been a lot of people sharing their personal journeys and stories, and I found that just amazing. So thank you guys so much.
And I think we have to thank Judge Hall herself. She's being very modest about the good trouble
Yeah.
she caused here, but thank
Yeah.
you, Judge Hall,
Thank you,
for,
Judge Hall.
thank you for instigating all this, because it's long overdue and very important and hard work, but we all know you did the lion's share, so don't act.
Yeah, otherwise we would have started with a blank piece of paper.
Oh,
We never
God,
would have
help us.
gotten here. Let's be fair, right?
We
I want to
wouldn't
thank
have- we wouldn't
everybody
have
as
that-
well. And
Let's
I
ask-
really feel privileged to have met folks that I wouldn't have crossed paths with before. You know, like I don't think Carol and I had ever met or anything like that. So that's been good fun, and I really appreciate learning everybody's perspective. And Sienna and Laura and Lauren, please tell Jill if she wants to talk to me, just call.
Thank you. Thank you all for trusting me to kind of bring this in for the landing. So
You've done such a good job, Sienna. I mean, you just did a really nice job with the report and all of the, oh my God, the cross references in the bill. I'm so grateful because I looked at that and I just wanted to hide under the bed. So I'm very grateful for that.
Any other last comment? Okay, thank you all, and we will adjourn at 2:45 before your heart stops.
See you at the doc,
I got
see you at the
5 whole
Doctorville task
minutes
force.
to wave at you guys. Wait,
Thank
the
you very
queen
much.
Have a good
wave.
weekend,
Thanks,
everyone.
everyone.
Okay, thank you
Bye-bye.
all.
Thanks, everyone.
Go
Bye.
Dodgers, beat New York.
You're here.
On a baby picture, Lauren.
Okay,
Yeah.
all right. Thank you
Bye-bye.
for coming. Bye.
Thank you.
Aye.
Bye. Thank you.